Now I would like to welcome Professor Thomas Kohler, Professor of Law and Philosophy at Boston College Law School, an authority on international labor and employment law, especially in the United States and Germany. He's written extensively on many of the issues that our assembly has been weighing. And he's here this morning to give us an international scan of perspectives and policies around worker voice in the world. We'll have a chance to hear from him and then have a little bit of a Q&A with him after he speaks. So good morning, Thomas. Thank you so much for joining our Assembly on Workplace Democracy.
Andrew, thank you. It's an exciting project to have going on, and it's an honor to have a chance to be part of it, even if only a small one. I'm going to talk for about 15 minutes, and I'm hoping that we'll have from that plenty of questions. So since I've been asked to speak on an international basis, or what I'd call as a comparativist, I want to remind people that in labor law especially, culture plays a hugely significant role as to what you can do and what won't work. Lord Wedderburn of Charlton, who named himself Charlton after his favorite soccer team, said, "The language of a labor law system can be learned only from its social history, and above all, the history of its labor movement." He said, without that, without some smattering of that, comparative conversation's impossible. Clyde Summers, who was one of the great American scholars and great expert on German law as well, said that making a comparison is always risky because of incomplete knowledge. Relevant considerations may be overlooked or misconstrued, and deep-running social attitudes or political values, historical traditions might be not accurately sensed. So obviously, I don't have time to delve into any of these issues, and I'm going to try to attempt to. My point is simply to caution that as you think through alternatives, whatever they might be, you have to pay special attention to what fits your own nation's history and culture, and why other things developed in other places, and will they really dovetail very well. It's sometimes I liken it to buying a television in Europe. You can't simply take it back to Canada or the US and plug it in. Not only is the plug different, but the broadcast protocol is entirely different too. So with that, I want to outline how I'm going to proceed today. And I'm going to proceed really in 4 steps. First, I want to give a brief outline of the Wagner Act model and its characteristics, which of course is the American model. I'll talk a little bit about where else it's found, and then what other systems exist: sectoral bargaining, coverage of workers, works councils, minority unions, and voluntary arrangements. Then I'll turn to talk a little bit about how different systems are faring in terms of union density, acceptance of employee voice by employers in different places, and what trends we're seeing. In doing that, I'll make some concrete remarks, mostly about Germany, but also about Japan. And then I'll talk about some very recent developments in the United States, California's Fast Recovery Act. So let's turn to the Wagner Act model. I know you're familiar with this largely. When I teach this to my own students, what I always remind them is that collective bargaining under the Wagner Act model is best understood as a private lawmaking system. It's what the German scholar Gertrude Teubner once called reflexive law. What do I mean by that? The law gives a framework for making law, that is the freedom to organize unions, the duty to bargain in good faith, etc. But Congress, the courts are not supposed to intrude into what the substantive terms are. So in a way, what Congress did in the United States in 1935 was say, unlike much of the rest of the world, we don't have any labor law. We'll give you a structure for making it. You want labor law? You make it. We're going to stay out of it. We'll give you a structure, but we're not going to intrude into the substance. Okay, the key aspects to the Wagner Act model. And the comment about adversarial bargaining, I'll pick up a little bit that one of the speakers was making just before I started, which was very interesting. The key to this model is, of course, exclusivity of representation and free collective bargaining. So, exclusivity of representation. To understand why we did this, you need to understand just a little bit of history. There's quite a bit to it, but I'm only going to touch very briefly on it. The whole idea was to protect the formation of autonomous employee organizations. When the Wagner Act was finally passed in 1935, employers and employees had been experimenting with all sorts of different ways of giving employees voice. In 1935, Congress had a real choice to make. Employer-sponsored representation plans of all sorts, sometimes called company unions, but many of them were much more than that, than just some sort of bare pretend union. The question really was, do we want something sponsored by employers, or do we want to clear the ground for employee self-organization? So much of the debate over the National Labor Relations Act was over exactly that question. The majority of what went on in the debates over the Wagner Act was simply over this. When the act was framed, the Congress defined labor organization very broadly to exclude employer-organized committees, plans, et cetera. So it's based on majority rule. If you want to bargain, a majority selected by the employees, as you know, becomes the exclusive representative of all the employees. When he was questioned about this, Senator Wagner said, look, I'm the senator from New York. Not everybody voted for me, but a majority did. I represent everybody. I have to do so fairly. Majority rules. He applied the same thing here. The other thing that with exclusivity was to protect, as I said, these autonomous employee organizations. By 1935, employer-sponsored organization plans were almost the same, covered almost the same number of employees as did unions. And they were overtaking them. So the question really was, what are we going to have? The adversarial model recognizes and accepts the differences between employee and employee interests. It really does something that Adam Smith talks about in The Wealth of Nations. He said employer, or master and servant, employer and employees are yoked by mutual need, but they also have differences of what they want. Employers want to have people work for as cheaply as possible. Employees would like to get as much as possible. So this model recognizes it. I might drop a footnote here. There's always been a dispute in industrial relations literature about the link between employee satisfaction and productivity. It's never been found. Carnegie Mellon University, its business school, did a study maybe 15 years ago now. Employer-sponsored voice plans of almost every sort have a shelf life of about 18 months. And the reason it's short is that normally the things that matter most to employees matter most to employers. And if it entrenches too strongly on employer concerns, employee voice sort of disappears. And with that, employee interest in being part of such plans. So the other thing about the Act, the National Labor Relations Act, is that it's a bottoms-up grassroots model. We have to remember that the Wagner Act wasn't invented by Congress. What Congress really did, what Wagner really did, in large part, was to look at what the employees and employers had worked out and then built the act around that model. So, as I said, it's bottoms up, and it's bottoms up, of course, in another way. Unlike many places, workplace in the United States, or bargaining in the United States, is either on a workplace model, workplace level, or enterprise bargaining, as it's sometimes called. There is, of course, multi-employer bargaining in some industries. It's not terribly widespread in the United States. Okay, with that as a very, very brief description of the Wagner Act, where else does this model appear? Well, of course, Canada to a large extent, but it's not fully adopted. The other place it is found is, oddly enough, in Japan. Now, you might say, well, why Japan? It was imposed by General MacArthur at the end of World War II. He saw independent unions as being an elemental part of a democracy, imposed the act. Of course, the Japanese have adopted, they've retained the act, they've adopted it to fit their own situation. So it's not a one-to-one correlation. The other thing about it that's interesting is that Japan uses the German code. It used that as its model for the rest of its lawmaking. So you have this very kind of interesting system that's American on one side, largely German civil law on the other side, that very clever lawyers have dealt with since. I think that's all I want to say about that. Other models of collective bargaining. Boy, there are a lot of them, and you've heard about some of them. One here is a lot about works councils, for example, employee representation on boards of directors, sectoral bargaining, and occasionally minority bargaining. So I'd like to talk about all of these briefly. The most famous of the systems incorporating all of these aspects, works councils, representation on boards, sectoral bargaining, and theoretically, at least, minority bargaining, is German law. So the first thing to understand about this is that all of these features work as an articulated whole. They dovetail together. So when you're thinking about any of this, you sort of have to think about it as a whole. These are components that fit together to build their system of employee representation through collective bargaining.
Thomas, I just want to jump in quickly and just give you a 5-minute warning.
Okay, good. The German system is a dual-track system. That is, theoretically, people are covered by sectoral agreements. For example, in Southwest Germany, the metal industry, the electrical makers, auto industry, very heavily industrialized area. There's one collective bargaining agreement that covers all the employers and all the members of unions. Those agreements are very general. So what happens, of course, is the works council, which is in the workplace itself, that becomes where the actual representation of employees occurs. So the works council works within the structure that the collective bargaining agreement puts together. Unions play a key role in grounding the works councils. I'll talk briefly about that in a second. There are long historical roots to all of this. So I was asked to speak about minority bargaining. I'm going to do that very quickly. In Germany, it's theoretically possible, but this was covered by something called the Tarifeinheitsgesetz, the unitary collective bargaining rule. The majority's collective bargaining agreement covers everybody in the workplace. It gets more complicated than that, but that's enough for the moment. In Japan, there's actual bargaining with minorities and minority unions. Employers have to do it. But my Japanese colleagues tell me that what really happens is the employer listens to them and says, that's nice. Thanks for coming in. They don't have the economic power to strike or put economic pressure on. So it largely is a formal right, not an effective right. Okay, a couple of things about what's going on in Germany in all of this, and then I'll talk very briefly about the California experience. Today, I looked this up last night. only about 6% of all workers in Germany are now covered through a collective bargaining agreement. In the East, the old Eastern Germany, it's only 39%. Those numbers have gone down over time. In terms of works councils, only 9% of all of the companies that are supposed to have them actually have one. These cover in the West about 40% of all workers, and in the East, 33%. Those numbers continue to go down. And one of the reasons is employers are, there's less interest in, more resistance to having works councils. So very quickly, in concluding then, the new FAST Act in California calls for a sort of joint industrial council where representatives of fast food workers, representatives of the public, representatives of the industry are supposed to meet together and set terms and conditions. That was signed into law a couple of weeks ago. We don't know what's going to happen with it. It is very new. There are a series of legal issues that may cripple it. We'll have to see what happens. So I was asked to give you 3 points of special importance that I'd like you to think about. And I'm going to do that and then quit and take questions. First of all, regardless of the system, wherever you look, unions and collective bargaining still give the greatest scope of employee voice and management decision-making. And they're absolutely integral to grounding things like works councils, employee representatives on the boards, et cetera. I don't have time to go into it, but the German system wouldn't work without the unions. Secondly, works councils, worker representation on boards, et cetera, are not new ideas. I looked at the proposals that very interesting ones that were on the screen before I came on to speak. Those are, as I say, very old ideas. Worker representation on boards in the United States goes back to the 19th century, in Germany even older than that. Where these ideas work well, they work well when they're grounded by autonomous unions and embedded in a legal scheme. If you don't have that, they tend to not work terribly well. The last thing is, in any consideration you make, regardless of what it is, the question always should be in the back of your mind, how much state involvement do you want? The California approach is a very interesting one. It moves towards a sort of corporatism, but without the sort of foundations one would find in Germany. It's not grounded by collective bargaining, but instead is a replacement for it because it's been so hard to organize unions. So another way to talk about this is social solidarity just about everywhere is a key problem. And if you don't think so, look at how split the United States is on almost everything. Andrew, that's all I have to say. And I know I'm over time.
That's okay. Actually, you caught up quickly, and thank you so much, Thomas. I really appreciate you you giving us that overview. I think a lot of the points that you brought up are exactly the kind of things that the Assembly has been wrestling with, and I would expect when we open things up to questions, we might get some on the subject of the sectoral bargaining, of course, the work councils and the union's role in them, which is also something that's been very strong interest among the Assembly. And the FAST Act model has been something that we've reviewed a little bit previously. So let me go ahead and open up the floor. Please feel free again to raise your Zoom hand or post a question or a comment in the chat. Remembering Thomas's kind of lingering points that I know connect with many of you. What is the role that unions can play in advancing all of this? And of course, how much state or government involvement? I know that's something that's also been interesting to note for some members. So I will go with the Zoom hands that I see up. And again, welcome to use the chat. Open the floor to anyone.
I just had one question, Thomas, or a clarification. With regard to the work councils model in Germany, you mentioned that the percentage is declining. and I was under the impression that it was mandatory, but from that comment, I'm concluding that it's not. There's some optionality or some means by which employers and unions have to agree on it, or?
That's a great question. The law says that any employer with 5 or more employees must have a works council. It's never been enforced, and most small employers don't have them, and never did. Where you really have found them has either been in very large companies like Mercedes, Audi, outfits like that, or what the Germans call the Mittelstand, the usually closely held, largely family industries, with up 4,000 employees maybe. This is the heart of the German economy. That's where these works councils have been thinning out over time. That trend is, there are a series of reasons for it. One of them is this. The sectoral bargaining, as I said, all this stuff's linked together. The sectoral bargaining it's built on the notion that groups of employers and a large union, for example, IG Metall, which is the world's largest trade union, represents all sorts of people in all sorts of industry. They will sit down and bargain. But more and more employers are leaving the employer associations, and when they do, the collective bargaining structure collapses. It's not on a grassroots basis the way the American is. There's one exception to this. That's VW. VW has its own special law, and that's also historically conditioned. So yeah, the other thing is that unions ground the way the works councils work. The unions train the works council's members. They provide experts, legal experts, economic experts, safety experts, medical experts. As the number of union members has declined, in Germany now it's under 15%. The amount of money the unions have to do this has also declined, which has thrown the works councils into more and more tenuous positions. So I hope that answers your question. If it doesn't, please follow up.
Oh, sorry, Andrew, you're on mute.
That's helpful, Thomas. Thank you.
Anyone else from our assembly want to put your hand up? Questions for Thomas around any of our issues? Yes, Douglas, I see you've got your hand up. The floor is yours.
Yes, I took note of your final comment in your presentation where you said social solidarity is most important. One of my concerns is if we are talking about democracy in the workplace, then yes, we need to have everyone coming to the table, everyone having a voice, everyone willing to listen, everyone willing to collaborate. And I think that's very important regardless of what system we're looking at. Without that social solidarity, I think any system would face major difficulties. So could you comment a bit more on what you meant by why social solidarity is so important?
Sure, and I think your points are wonderfully well taken. If you look at the United States, for example, we're terribly split, or so it seems, on all sorts of issues. So the question has been raised by many, can the country even continue to exist? The notion that we've got something in common that we need to talk about is the basis for any democracy, as you said. The idea, too, with solidarity is that for the common good, sometimes you're asked to sacrifice some of your interests because other people have a higher claim or a more important claim. In return, when you need help, they're supposed to back you up. If we lose sight of that, that undermines the idea that we have anything in common at all, which undermines eventually the rule of law in a democratic system. So then you end up either with force, which of course is unstable, or chaos until somebody uses force. So in the collective bargaining area, it's interesting in Germany, individualism is something that is far less expressed there than it is in the United States. Of course, we're famously outliers. We're the most individualistic people in the world. That's one of the reasons that our union membership has always been lower. A few years ago, a very distinguished, rather conservative labor law scholar, who's a friend of mine, a colleague of mine, started a speech before the German Bar Association, their law institute, by saying, your generation, meaning the older generation, understood solidarity, but we're the generation of individualism. You like soccer teams, we like individual race car racing. That was his model. To the extent that that becomes the model, it's very hard to organize anything. Union decline in the United States went along with the decline of every other sort of mediating group, whether it's political parties as they used to exist, social clubs, churches, any sort of voluntary association. So all of that's tied to social solidarity. Labor law rests on that, but it rests on a social substrate too.
All right, thank you so much. I want to thank you again, Thomas, for that presentation, giving us a lot to think about, and indeed touched on all the things we have been discussing. I just want to acknowledge there's a couple of comments that have come in the chat regarding the Sandra mentioning the decline in the solidarity seems to parallel the increase in voice on the individual level. And I know as this assembly has wrestled a lot with individualism, collectivism in the modern age with respect to this question around worker voice, I think that's a point well made, Sandra. And Elaine's point as well, just about declining interest in unions. One of the things our assembly is wrestling with is how to make unions relevant again through this exercise of reforming and improving worker voice. So it seems you've kind of got everyone started thinking about that. So thank you again so much for joining us. We're going to move on shortly into a breakout discussion to kind of continue this going. But Thomas, it was wonderful to have your perspective from around the world on some of the practical sides of these mechanisms that our assembly is working with. And we thank you so much for joining us.